just last June, he decided that liar case, the Alvarez case, where the court threw out the federal law that made it a crime to lie about receiving the Medal of Honor. He wrote a very courageous opinion in the virtual child pornography case that we'll consider last in this course, actually. I mean, what elected judge would want to come out in favor of protecting child pornography? But Kennedy did. And he, of course, and this is perhaps not something that he wears as a badge of honor, but he probably thinks it's great, he wrote the opinion in the Citizens United case, holding that corporations have a First Amendment right to put money into political campaigns. Then next in order of seniority, oh, well, that was Kennedy as a hero, is Justice Clarence Thomas, who has an amazing life story. He was appointed to the Supreme Court by the first President George Bush Sr. in 1991, after having spent a year on the District of Columbia Court of Appeals. His confirmation hearings were enormously controversial because he was accused by a law professor by the name of Anita Hill of having engaged in sexual harassment, making her the victim of it, while he was head of the Federal Equal Employment Opportunity Commission that Reagan had appointed him to. Thomas is now 65 years old. He was born in a little hamlet in Georgia, Pinpoint, Georgia, in complete poverty. Not an intact family at all. He was largely raised by his grandfather. He studied for the priesthood and then went to Yale Law School. He got a job out of law school working for Senator Danforth in Missouri, and then went to work for Monsanto, the agricultural chemical company, in the pesticide division of Monsanto. As I said, Reagan made him head of the EEOC, where he instituted very conservative policies on affirmative action. The court's going to have a big affirmative action case this term, on class actions, limiting the ability of people to band together in a class to sue about employment discrimination and so on. He, as you're probably aware, virtually never says anything in court. He has not asked a question on the court since 2006. He's the only justice who never asks a question. As it happens, last week he said something during an argument. It apparently was a joke, and the transcript of the argument doesn't quite resolve what it is he said, but it got a laugh. Somebody was arguing a death penalty case that the lawyer who had represented the condemned man was competent and so on. Even though he was only a year out of law school, he had gone to the Yale Law School, and that was some sign of competence. And that's where Thomas jumped in and said something like, that's no sign of competence. He's no fan. He's been highly critical of Yale Law School and wants to disavow anything to do with Yale Law School if he can. On the First Amendment, Thomas has been uniformly terrible. He, especially with regard to any issues that involve children, minors, the rights of minors, they don't have any First Amendment rights. You'll see in the Bong Hits case what he had to say about that, in the video games case what he had to say about that. He, along with Antonin Scalia, is an originalist. That is, the two of them believe that the Constitution should be interpreted to mean what the framers of the Constitution, back in the 18th century, what they would have understood it to mean. It's not an evolving document. It doesn't change with the times. What it means is what it meant to the framers in the 18th century. But he doesn't say much during arguments that tip his hand on what he might come up with. Politically, he's a rock-ribbed conservative, as is his wife, who is politically very active in Tea Party type activities, which some people say he should recuse himself from cases involving political disputes, but he doesn't. Then next in order of seniority is Ruth Bader Ginsburg, who was appointed by Bill Clinton in 1993, 20 years ago. She's now 80 years old. She's had cancer. She's very frail, but she hung on through the Bush years, and she hung on through the first Obama term. I would expect her to resign sometime during this next Obama term to give the appointment to Obama. But who knows? She comes to work every day, works hard, and does wonderful work. She grew up in a working-class neighborhood in Brooklyn. As I said, she went to the Harvard Law School but then transferred to Columbia. After law school, she taught at Rutgers Law School in New Jersey, and she worked with the ACLU running their women's rights project. And she personally argued 6 women's rights cases before the Supreme Court. President Jimmy Carter appointed her to the D.C. Circuit Court of Appeals, which is sort of a feeder for the Supreme Court. And then, as I say, Clinton appointed her to the Supreme Court. On First Amendment cases, she is very strong. She's very consistent. She doesn't waffle about these cases. In the FCC indecency case last year, she was the only justice willing to stick her neck out and say, we ought to get rid of this. Our cases that have authorized the FCC to regulate indecency were wrong, and it's time to say so. But she was a minority of one on that point. Then there's our local boy from San Francisco, Justice Stephen Breyer, who now 73 years old. His father, Irving Breyer, was the attorney for the San Francisco School Board back in the day. Breyer went to Lowell High School in San Francisco. Any of you go to Lowell? Only one, really. Huh. They have a picture of Breyer in the school? Yeah, I bet they do. And he visits there every once in a while. Yeah. He was appointed by Clinton in 1994, and his confirmation was not controversial at all. He was confirmed by an 87-9 vote. He, like so many of the others, went to the Harvard Law School. Then he clerked as a Supreme Court clerk for Justice Arthur Goldberg. And Breyer was a year behind me in law school. I knew his name, and that was about it. He, after clerking, worked in the antitrust division of the Justice Department, and there met his wife, who is the daughter of a wealthy British aristocrat, and they lived sort of a transnational lifestyle. He taught for many years at Harvard Law School, and then was Senator Ted Kennedy's man on the Senate Judiciary Committee. He worked for several years on the Senate Judiciary Committee, and there got to know all the senators and got a lot of respect from senators, and I think that probably eased his confirmation. They knew that he could be trusted and that he wasn't going to do crazy things. I mean, he'd been interested in things like deregulation of the airline industry and so on. Jimmy Carter appointed him to the First Circuit, and then Clinton to the Supreme Court. On the First Amendment, Breyer is a bit of a disappointment. He is supposedly a political liberal, but he instinctively is an accommodationist. He wants to see all sides of the problem. It's never black and white, it's always gray, and he wants to see if there isn't some middle ground here. And in First Amendment cases, that's very hard to do. Either you have that right to say those ugly things or you don't. And he's forever trying to find some compromise position. He's also entirely too willing to defer to the judgment of Congress and state legislatures about the need to have laws restricting speech. The notion is one of judicial restraint, that we're judges, we're not the ones who have to take the heat for, we're not the ones who ought to be deciding. It's not within our purview, legitimately, for us to decide what's good for society and what's bad. That's a legislative judgment. Judges shouldn't be doing that. But he's not ideological at all, unlike Thomas or Alito. He's very pragmatic, looking for reasonable solutions on everything. Justice Daniel Alito was one of the two George W. Bush appointments to the court. He was appointed in 2006. He's now 63 years old. He was appointed from the Third Circuit Court of Appeals, which sits in Philadelphia and includes New Jersey, where he's from. He, as you may remember, was second choice, W's second choice to fill a vacancy on the court. President Bush first wanted Harriet Miers, who was his lawyer in the White House, to serve on the Supreme Court, but it became obvious very quickly that she was completely unqualified to serve as a justice of the court, and her name was withdrawn, and Alito was put forward. And he was intellectually qualified, without a doubt. He'd gone to Princeton, he'd gone to Yale Law School, he'd served on the Third Circuit, he had worked in the Reagan Justice Department. No question about his qualifications. On the First Amendment, he has been uniformly terrible. Really disappointing. He appears to be very rigid and moralistic. We'll look at some of his opinions where he's morally offended by the speech that is in question. For example, he dissented in the Liar case that we'll see. He dissented in the video games case. He dissented in the funeral protest case. Eloquently, forcefully. He just can't tolerate speech that is so anti-majoritarian, so disturbing. As you may recall, when the Citizens United case was decided in 2010, about 3 or 4 days later, President Obama appeared before Congress for his State of the Union speech, and customarily, most of the justices of the court go and attend the speech, and Obama went out of his way. He's standing this far from the justices of the court, looking down at them, and he scolds them for having decided the Citizens United case the way they did, and he said, and the decision will open up to foreign corporations the ability to influence by American elections. Whereupon the television camera panned to Alito, sitting next to Sotomayor, and he mouths, "Not true. Not true," and it wasn't true. He was right. That point that Obama was making was really not accurate. But he's sort of not a big Obama supporter, and Obama's not a big supporter of Alito. Then we have the two Obama appointments, Justice Sonia Sotomayor, his first appointment, actually. She's now 59 years old, the first Hispanic on the court. She's a Puerto Rican. She, too, has an amazing life story. She grew up in the public housing project in the Bronx, somehow or other, made her way to Princeton to college, and then Yale Law School, like Alito. She was appointed to the Federal District Court in New York by George Bush I. Although she is a lifelong Democrat, she had been recommended by Senator Patrick Moynihan back in the days when we had a more bipartisan scene in Washington. Anyway, she got onto the bench that way, and then Bill Clinton elevated her to the Second Circuit in 1997. She came out here to Berkeley in 2001 and made a speech in which she said, "I would hope that a wise Latina woman with the richness of her experience would more often reach a better decision than a white male who hasn't lived that life." That speech came back to haunt her during her confirmation hearings. She survived them, was able to explain it or make it go away in some way. She replaced on the court Justice David Souter, who'd been an appointee of the first President Bush, and had gotten away from the conservative mold. He had been represented as a solid conservative who would do the right thing for the conservatives, but the longer he served on the court, the more he moved to the left, so that by the time he retired and went back to his little cabin, and he's a bachelor, went back to his little cabin in New Hampshire, he was what passes for a liberal on the Supreme Court. And Sotomayor's appointment probably moved, substituting her for Souter probably moved the court incrementally to the left, but not very much. On the First Amendment, how has Sotomayor been? So far, so good. I can't fault her on any of the decisions she's made. She hasn't written the opinions in any significant First Amendment case, but she has voted the right way. And at arguments, she appears to be appropriately skeptical of government arguments about why we need to suppress this kind of speech. She has a sign in her chambers, the New York Times reported last week, that says, "Well-behaved women rarely make history." And as you may have noticed, she has just published, this last week, her memoir called My Beloved World, which describes her life, which is inspiring, up to the moment when she took the bench. That's where the memoir ends. And it was reviewed very favorably. The New York Times a couple of days ago reviewed it and pointed out that she says, I haven't read the memoir, but I believe this woman who writes the reviews for the Times, she said when she was in college, remember she went off to Princeton, right out of the Bronx, went to Princeton. In college, she received a C on her first midterm paper. and realized that she needed to learn how to construct more coherent arguments, and that she also needed to improve her English, which was, she said, riddled with Spanish constructions and usage. Over the next few summers, she says, she devoted each day's lunch hour to grammar exercises and to learning 10 new words. And she tried to catch up on the classics, reading The Adventures of Huckleberry Finn and Pride and Prejudice that she'd missed out in her youth when there was little to read around the house besides the Reader's Digest. So if you get a C on your first paper in this course, don't despair. You can grow up to become a justice of the United States Supreme Court. And then the new kid on the block, Elena Kagan, Obama's second appointment, appointed in 2010, now 52 years old, youngest member of the court. She too went to Princeton and then Harvard Law School, and she clerked for the great Justice Thurgood Marshall when she got out of law school. Then she worked for a time for a Washington law firm, then served on the faculty at the University of Chicago Law School, where she was a colleague of Barack Obama's. They were on the faculty at Chicago at the same time. She published a couple of law review articles, very scholarly, larded with footnotes and so on First Amendment doctrine. But there's nothing that I've discovered that is very interesting or controversial about her positions, her scholarly positions on First Amendment issues. She was lured from Chicago to go to work in the Clinton administration, and then Bill Clinton nominated her to serve on the D.C. Circuit Court of Appeals, but the partisan bickering had already set in by then, and the Republicans stalled the appointment, and Clinton left office, and she was not given the job on the Court of Appeals. Instead, consolation prize, Harvard Law School made her the dean, the first female dean of the Harvard Law School. And then, while having served for, I think, about 6 years as dean and doing an excellent job there, Obama appointed her Solicitor General of the United States. What's the Solicitor General? That's the lawyer for the government in the Supreme Court. The one who signs the briefs, the one who stands up in the court and argues the case on behalf of the United States of America. The government has a lot of cases in the Supreme Court, and the Solicitor General holds an extremely important position in representing the government in all those cases. The Solicitor General, all the male Solicitor Generals used to wear morning coats, or I'm not sure what you call these things, tails, with striped pants. Still do. When they argue in the Supreme Court. She got a special dispensation not to dress up in an outfit when she was Solicitor General. She argued the Citizens United case on behalf of the government while she was Solicitor General, lost the case. And she had, before she was appointed to the court, not argued any case in the Supreme Court, except for Citizens United. She was the only justice not to serve on the Federal Court of Appeals. Notice that it's justice on the Supreme Court and judge in the Court of Appeals. No particular good reason for that, but that's what they call them. California, it's different. They're justices of the Supreme Court, justices of the Court of Appeal, and judge in the trial court. Anyway, Kagan replaced one of my favorite all-time Supreme Court justices, John Paul Stevens, who served for a very long time on the court. He was President Gerald Ford's only appointment to the court. He was nominally a Republican. During his tenure, long tenure on the court, he became more and more liberal. He was probably the most liberal member of the court at the time of his retirement. And I think it's, in my judgment anyway, that appointing Kagan instead of to replace Stevens probably moved the court incrementally to the right, because she's a bit of an accommodationist and not consistently taking liberal positions. Remains to be seen. She's still very new to the court. But in the last term, for example, she voted with Justice Anthony Kennedy 83% of the time in the last term of the court. So let's look at that term and how the court actually has been doing its business. It sits in terms. Each term of court begins, anybody know when it begins? The first Monday in October. Every year, the new term of court begins. We're now in October term 2012. The cases that are decided this year will say, they'll have a number on it, 12- whatever number of the case it is. The court starts hearing cases in October and hears arguments in cases up through about the first week of April. It hears about 40 days. It has about 40 days of arguments during any term and decides annually about 75 cases, not very many. Last term, October term 2011, the court decided 75 cases, only 65 after hearing argument. They decided 10 of them summarily, without hearing argument, which is unusual, including one of the Citizens United follow-up cases that we'll talk about week after next. These cases that the court decides, 75 a year, they quit at the end of June, the term's over. They don't decide any cases again until the next term. They try to wipe the slate clean, decide all of the cases that they've decided to hear during the term, and then the term's over, and they start with a clean slate in October. But the 75 or so cases that they decide are selected from about 8,000 cases that the court is asked to hear, formally asked to hear every year. And the way you ask the court to take your case, I mean, people come strippingly off the tongue. I'm going to